approaching 5 minutes after 7 o'clock in Trinidad and Tobago on what feels like if it's going to be a rainy day for most of us in Trinidad and Tobago. But let's move right on. Talking about rain. Rain has washed out the match between Afghanistan and New Zealand at the World T20. That's after the earlier rain-affected match resulted in a victory for Ireland, shocking England in the early match of the doubleheader at the MCG in Melbourne, Australia. Of course, the West Indies eliminated last week, and that has had quite a few repercussions already with the impending resignation of the head coach, Phil Simmons. So let's move along. We talked about the award to Jawala Rambaran earlier this week in the broader context of good governance. Let's now talk about the award to former Government Minister Karen Teixeira, who's challenging Keith Rowley for the leadership of the PNM because she is apparently going to receive more than 18 million in compensation from Gulfview Medical Centre and one of its doctors. This after the Privy Council in the UK upheld the ruling of a High Court judge and the local appeal court. And indeed, the local courts found that the doctor and the medical centre were liable by way of negligence for the death of Nunez Teixeira's husband in 2004. That's Russell Teixeira, the former national central defender, footballer and captain, and of course insurance executive. Well, to give us his perspective on this, we're joined by attorney at law, Martin George. And if time allows, and if he's keen to, I'll squeeze in a few questions on Tobago Carnival, because he is, of course, head of the business community as well, one arm of the business community in Tobago. Good morning to you, Martin George. Good to have you.
Yeah, hi. Good morning to you, Fazil, and good morning to your viewers, and good morning, Trinidad and Tobago.
What do you make of
yes. That Miss Nunez Teixeira, her war chest has now expanded considerably.
Well, that assumes she's going to see that money anytime soon.
Well, it's a final decision, so I guess she would.
But just on that point, I mean, you're familiar with these things. In a matter like that, what is the time lag between an award, let's say in this case the Privy Council, which we still have as our highest court of appeal, and actually receiving the money? How long does that take?
Once there's no stay of execution, and I didn't see anything indicating that there was any stay, then she can make the claim for payment immediately.
So a week, 2 weeks, a month, a year, 10 years?
I mean, normally in a circumstance like that, yeah, you would ask that, within 7 days or so that they issue the check.
Okay. And what is your perspective on this entire matter? Because sadly, this stems from...
I'm very heartened by this, Fazil, because for too long, the awards in medical negligence cases in Trinidad and Tobago have been way too low. They've been abysmally low. We've seen, mothers lose their babies and get $22,000. What could you even begin to do with that? But of course, we have to place it in context. The largest part of this award would have been based upon the loss of prospective earnings or loss of future earnings, as it's referred to. Remember, Russell was a top flight insurance executive. He was earning at the highest level. So when you calculate for the lost years of his life and you calculate his likely earnings, that is what made this award so high. So we still have to put it in context, and I want the public to understand that this would not apply to the ordinary Joe like me or you, Fazil, right? Okay, Russell was in a different league and a different category entirely, right? And it's because of the prospective loss of earnings why this award was so high. So it's not necessarily to say that, look, this is going to apply across the board in all cases going forward. But Fazil, the thing is, I'll tell you why it's also important, because you see, it's through things like this that the medical profession basically has to take stock of itself and say, hey, listen, how can we improve our systems and procedures to avoid things such as this? I mean, Fazil, we have seen some alarming and amazing scenarios in our time here. For instance, Fazil, if I put up my hands here, I'm sure you could tell the difference between my right and my left hand. Okay? Now, you would think that this is a basic training that medical doctors would receive. Because we've had a situation where a patient went into one of the public hospitals with a gangrenous right big toe, right? They diagnosed it and they said, well, look, yes, this right big toe needs to be cut off, right? He went in for surgery, When he came out from surgery, his family was in alarm and shock. They cut off the left big toe, and the right gangrenous big toe is still there, waving at them and looking at them, you know? So, I mean, you're talking about crazy scenarios that have happened. So these awards, I think, will help to bring the medical profession to a state where they say, hey, listen, we have to start to self-regulate in a more robust and stringent manner. All right. First, let me give you another example, right? And these are matters that we have done. So I am speaking firsthand, right? When is a neck not a neck? Can you imagine if a surgeon has instructions to make an incision in the neck of the uterus of a woman who is there to deliver her baby, and instead, for you, the incision was made in the woman's actual neck? Can you imagine that? These are real scenarios I am telling you about. I'm sure you would recall that matter that concerned the matter where the mother and the child died in the Tobago, in the Tobago hospital.
Yes.
So, I mean, you are talking about some alarming scenarios. That is what the one that triggered a whole commission of inquiry and investigation, where a Canadian forensic pathologist had to come down and stuff like that. And that's the only way we got the truth out in that matter. So, I mean, these things, I think, are wake-up calls for the medical profession. And it's not to say that you are trying to punish medical doctors. I think the idea is to ensure that they adhere to the standards. There are two main standards, for you, that are used to determine medical negligence and to basically police, so to speak, the medical profession. One would be the Bolam test, and then there's the Bolito test. The Bolam test basically indicates that, look, you must hold yourself to the standard of reasonable care that is accepted by a body of competent medical professions at that same level. So in other words, your medical negligence is in default, not really fault. So in other words, if you deviate from the standard accepted practices, then you could be veering into the area of medical negligence. And then, of course, that Bolam test was refined in the later case of Bolito, and you have the Bolito test, which says that that body of opinion of medical men must be reasonable and reliable. So in other words, it can't just be that you call, as you see in the US, where you could basically buy any expert opinion you want. You could get somebody to come and give an expert opinion to say the sky is green, if you understand me. So they say the opinion, the medical opinion, must be reasonable. So these are the ways that you look at it to determine, well, okay, what is medical negligence and what can be done? I'll just give you a few more examples for you from our decided cases.
Sure. And while you're pausing to wet your whistle in that sense, but given, and I'm glad that you presented the context of the award based on the potential earnings of Russell Teixeira before he started passing in 2004. Doesn't that mean then that really things haven't changed? Because again, if it happens where a child dies or a mother loses a child, you might end up with the same $20,000.
And that's where we keep calling on those in the judicial system to revisit and to have a fresh look at these matters. Because I'll give you an example. Anthony Jordan versus North Central Regional Health Authority. And bear in mind, for you, all these cases are cases which this is public knowledge. So these are decided cases. Okay? All right, so it's not anybody's privileged information that is being
nothing sub judice or anything, right?
Sorry?
Nothing sub judice or anything.
No. All of these are decided cases, right? So Anthony Jordan versus NCRHA, right? He went in as a result of an accident. He got a broken hip. He was there for more than 24 hours untreated, just lying there waiting for his assistance. The man is in pain and stuff like that. Now, the accepted medical opinion is that, look, a hip that is fractured loses its viability after 12 hours. So in other words, once you go past 12 hours, you know that basically the man has basically gone past the point of no return. He developed cauda equina syndrome, which had the effect of loss of sensation, erectile dysfunction, and a whole host of other factors that the man suffered as a result of the failure to treat him within that 24-hour window. Right now, he was awarded the amount awarded was 450,000. Now, I mean, most people would feel that that is not adequate given those circumstances. All right. Then you had Samde Harilal versus Southwest Regional Health Authority. Right. In this case, she was awarded 140,000. The Court of Appeal later reduced it to 120,000, where she suffered the loss of her baby, right, while trying to have the baby delivered at the facility of the SWRHE. Right? There was no obstetrician on duty because the doctors were taking industrial action at the San Fernando General Hospital. So you could imagine you go in to deliver your baby and you have no medical professionals there to assist you because the doctors on strike. So the Court of Appeal castigated the action of the doctors in that regard. And, they said that the public interest, more so was harmed because of action which was resulted from the unprecedented industrial action taken by medical doctors at a public hospital. So this poor lady went in to deliver her baby, did not get the professional help because the doctors were on strike. So she was awarded 120,000 by the Court of Appeal in that matter. All right. You have also Paula Mac Joseph and Hugh Joseph. In this matter, it was a misdiagnosis. He went in with chronic pelvic, his wife went in with chronic pelvic pain. And the doctor misdiagnosed it and said that she has an infected left fallopian tube. So her pelvis has pain. They misdiagnosed it and said it's an infected left fallopian tube. They ended up doing surgery, removed both her fallopian tubes. She therefore became permanently sterile, and then she still had the chronic pelvic pain because they never treated what she came in there for. So you made her sterile, right? She loses her opportunity to have children in the future, and then the chronic pelvic pain that she came in with is still there. So
and Mr. George, before you continue, I know that there'll be a number of matters, and I'm sure this thing, it's a very difficult situation because there are many different things that come in here. Because I wanted to get to the point of whether doctors might be fearful that it could become open season on them now with legal action. But before getting into that, how difficult is it to assess costs? Because I'm sure Ms. Dinesha would love her husband to be with her rather than having to get 18 if she had to choose. How do you assess costs if somebody is misdiagnosed and loses the ability to have children? Is $10 million enough to not be able to have children? How does that process work? Is it a transparent process?
Right. The thing is, because it's very unscientific. I mean, we have rough guidelines. For instance, if someone suffers pain and suffering in the process, and therefore you use the seminal case of Cornelia versus St. Louis, where they've set out the 5 heads under which you make that type of assessment. You look at the pain and suffering, you look at the loss of future earnings, loss of pecuniary prospects, etc. So the extent of the injury. But that is if the person has suffered that type of injury there. But the fact of the matter is that what we rarely go on is decided cases and authorities within our jurisdiction. You see, that's the unfortunate thing. We're not able to rely on what you would see happening in the cases in America or in Europe, where you may see higher awards. We are limited by our cases in our jurisdiction. And in that scenario, in the Caribbean context or West Indian legal context, our awards are always abysmally low. So we are hoping that these things would stimulate the process to ensure that the courts and the judges look at this with fresh eyes and start giving higher awards in the circumstances.
And,
right?
And before you continue, because I know you're a man with reams and reams of information and context and history and so on. But what about the other side of the coin? That the legal profession might say, look, you know what? If they ask me for a diagnosis or whatever, I will say, I don't know, go by somebody else. Because next thing you know, they come with me with some legal action. So the best thing is, I don't know, don't ask me nothing.
You mean the medical profession?
Yes, the medical
Right.
profession.
So the point is, doctors are mainly covered by the MPS out of London, the Medical Practitioners Society. Right. So they usually have their insurance with them, and you have law firms in Trinidad who are retained by MPS, right, to ensure that the interests of doctors is protected. All right. And they actually do a very good job in that sense. So we will eventually morph for zero, I think, to a system similar to what you see in the US, where the insurance really now becomes the biggest factor. In other words, the doctors have to ensure that they have their insurance, the hospitals have to make sure they have insurance, and therefore the insurers now will actually be the ones who basically are calling the shots. So the protection would be there for the doctors in the event that things go wrong. And the fact of the matter is that you would expect that, look, sometimes things do go wrong, and the fact what we try to do is to minimize risk and to try to ensure that, these things don't happen repeatedly, So even an institution for zero can be held liable. So it's not just doctors, an institution can be held liable, all right? So the case of Cassidy versus Ministry of Health, that set the test to show that, look, an institution, a hospital, right? Because what the case said is that, look, the hospital functions through its agents, its servants, the doctors, the nurses, whoever. So therefore, if they are negligent, then of course the hospital itself can also be held negligent. We had a scenario for zero, and this is at a private hospital, and this one was really alarming, where through a botched surgery, which was done on our client, all right, he ended up bleeding profusely through his rectum. And the private hospital, instead of them going back in and fixing what they had done wrong, right, they simply started stuffing him with cotton pads and cotton balls, basically to soak up the blood, Then when his family, made a fuss, they said, well, okay, first to go back in, you need to pay for a new surgery. And the family was at that point were like, we have no money to pay again to fix what you did wrong, And for this is the most alarming part of it. The private hospital then dialed 999, called the ambulance, and sent him to Port of Spain General Hospital. That's the kind of thing that must stop.
Okay, and
we
just
have to safeguard the public's interest in that regard.
okay, and therefore, because this topic is so involved, we don't have time to talk about Tobago and Tobago Carnival and so on. But do you think, not just this award, but if it's a general trend, are we moving towards greater accountability, greater levels of fairness in this process? Are you seeing that happening at all?
I'm seeing it happening slowly for zero. And, whereas previously, people would say, well, one doctor would not give evidence against another. No, that is changing. And what you also see is scenarios where, for instance, persons, if it is they're not getting the expert opinion locally, they seek it abroad. Okay, like if you remember the case of Smokey and Bunty, right, where Smokey, went for his cancer treatment, and the radiation machine was malfunctioning, and they still administered radiation to Smokey. They basically fried Smokey there at the cancer center, right? So when his family took him abroad to Jackson Memorial and they did their test, they found such a high level of radiation. They said that it was radiation necrosis, right? That they discovered in him. And it's those reports that they were able to use in court to get the award of $2.2 million. And then they got 200,000 US for the stay at the Jackson Memorial and his funeral expenses. But the point is, Fazil, you have to ensure, and this is what we in Trinidad and Tobago have to realize coming out of this. We have to ensure that doctors don't see this as, basically attacking them or putting them under pressure. This is to ensure that the standards of professionalism are raised in our country. Because, for instance, in the case of Grace Primer versus Attorney General, the court was very critical, and the Court of Appeal also, of the nurses who did not read the notes, even though the notes were highlighted in red to say, look, this is a high-risk patient, and as a result, you have to take certain precautions. They ignored the notes, and they encouraged the mother to push out the baby. The mother was a high-risk person. As a result, the baby was stillborn. The umbilical cord was wrapped 3 times around the baby's neck. And when they realized, they said, oh, we didn't check the notes. But it had been highlighted in red that this was a high-risk patient. So therefore, that kind of negligence is the type of thing that we have to ensure that these cases bring an end to, and that we in Trinidad and Tobago are more vigilant in terms of our rights in this regard. And of course, as I say, doctors now use this as a wake-up call to ensure that they raise their standards of professionalism and the care that they deliver to patients.
Martin George, always good to get your perspective. Thank you very much once again.
Always a pleasure.
Attorney at Law Martin George there with us, 7:25 in Trinidad and Tobago. So many things come to light in the course of our discussion. As I said, 7:25, let's take a break and we'll come right back.
My so-called friends, they're just watching and laughing.